Good morning. My name is Michael Savoy. Welcome to day 2 of the California Board of Accountancy meeting. It's Friday, September 21st. To start, I'd like to take a roll call to establish a quorum. Mr. Jacobson?
Dan Jacobson.
Carrie Ann Farrell Hines.
Katrina Salazar.
Mary Gion.
Sochi Leon.
Mark Silberman.
George Familat.
Michael Savoy.
Jose Campos.
Okay, we've established a quorum. I'll now turn it over to the judge.
All right, good morning. So the first matter on the agenda for that the board will hear is going to be the petition for the reduction in penalty of James Michael Turnbull. Is that correct?
Correct.
All right. So Mr. Turnbull, we're going to be on the record here just in a minute. We have a court reporter here. He is seated right to your left.
He introduced himself.
Good. And so once we go on the record, I'm going to announce the case. I'm going to have the Deputy Attorney General announce himself and have you announce yourself. And then I will explain how the hearing is going to proceed this morning. And then if you have any questions, you can ask me at that time. All right?
Yes.
All right. And I'm not hearing you, so I'm just wondering if your microphone is, maybe you could pull that just a little closer.
I'm a soft-spoken person anyway.
There you go. That's better. Thank you. All right. On the record. Good morning. We are on the record. It is September 21st, 2018, in the matter of the petition for the reduction in penalty of James Michael Turnbull. This matter is being heard before the Board of Accountancy, Department of Consumer Affairs, State of California. This is OAH number 2018-070242. My name is Marcy Larson. I'm an administrative law judge with the Office of Administrative Hearings. I'm presiding over the matter this morning. We are here at the date, time, and location of the notice of hearing in this matter. And I'm going to ask the board members to please identify themselves for the record, starting to my left.
Michael Savoy.
George Familat. Mark Silberman.
Sochi Leon.
Mary Gion.
Katrina Salazar.
Carrie Ann Farrell Hines.
Dan Jacobson.
Right, and there is a quorum present. And may I have the appearance of the Deputy Attorney General, please?
Yes, good morning, Your Honor, members of the board. I'm Deputy Attorney General Carl Sani. I'm appearing here on behalf of the people of the state of California pursuant to Business and Professions Code Section 5115.
Right, good morning. And Mr. Turnbull, you're representing yourself this morning, is that correct?
I am.
All right. As I mentioned before we went on the record, I'm going to explain how the hearing is going to proceed this morning. And then if you have any questions, you can ask me at that time. So this proceeding this morning before the board is concerning your petition requesting a reduction in your penalty. The board members have the benefit of your petition package. And so the board members would like you to focus on providing information concerning your rehabilitation and the basis for your request, although you don't have to repeat what's in the petition package since they do have the benefit of having that and having read it. The Deputy Attorney General is going to proceed first. He is going to identify the documents in the petition, and I will mark those as exhibits. I will ask you if you have any objections to any of the documents that are presented by the Deputy Attorney General. You may object to any of those documents, but you have to have a legal basis to object. If you have an objection to a document in the petition package, but you don't know what the legal basis is, just tell me you have an objection, and I'll get more information from you. And then I'll make a ruling on whether or not the board can consider a document if you've objected to it. You also have the opportunity to present any documents. Did you bring any additional documents with you today?
Just updated financials.
All right. So after the Deputy Attorney General presents the documents, then I'm going to have him give the board an overview of the history concerning your discipline and the information that's contained in the petition package. And then you're going to have an opportunity to then present your case. You can present the documents that you've brought with you today. I'll mark those as exhibits. And the Deputy Attorney General, after you present your case, will have an opportunity to question you. And then after the Deputy Attorney General is done questioning you, I will open up any questions that the board members might have, and each of the board members will have an opportunity to ask you questions as well. And then after the board members have asked you questions, I will ask you if you have anything else that you want to add. And then I will allow both you and the Deputy Attorney General to provide any closing remarks to the board. After the hearing, you won't get a decision today from the board. The board will go into closed session today and consider your petition, and then you will receive a decision sometime in the future. The board has 30 days to issue their decision. I have 30 days to assist the board in issuing their decision, and then I'll have you speak to the Deputy Attorney General about when you might receive it after that. All right? Any questions before we get started?
No.
All right, then. With that, then, Mr. Sonny, if you would please present the petition documents and give the board a brief orientation of the matter.
Yes, Your Honor. Thank you. Again, thank you, members of the board and Your Honor. I would first like to mark for identification and offer into evidence as Exhibit 1 the original petition in this matter with the accompanying documents. The board members and the petitioner have been provided copies of those documents. They total about 72 pages. They're denoted as JMT-PET-001 to 72. I'm going to refer to any pages by simply referring to it as PET followed by the page number. I would request at this time, Your Honor, as indicated prior to the proceeding beginning, that Mr. Turnbull's financial information, which is found at page PET 13, be placed under seal on the basis that it contains confidential personal financial information of the petitioner that is generally recognized as protected under California Constitution as a financially private matter. Board members can obviously review it, but we don't think it needs to be a public record at this time, Your Honor.
All right. Mr. Turnbull, any objection to the petition package, Exhibit 1? Any of the documents? Do you have any objection to any of those documents?
None.
All right. Exhibit 1 is admitted. And then any objection to having page 13 sealed from the public?
No.
All right. So the way that this will be handled is that I will issue a protective order sealing page 13. And then I will serve that protective order. You will get that protective order in the mail, Mr. Turnbull, as well as the Deputy Attorney General. You'll get a copy of that. It will also be provided with to the board. And what it will do is if anybody from the public requests the petition package, that particular document will not be produced unless there's an exception that allows it to be produced or if a court orders it to be released. All right?
Yes.
All right.
Thank you, Your Honor. Mr. Turnbull received his certificate number 76917 on January 7th, 1999. His license history is set forth at pages PET 54 to 56. Normally at this time, Your Honor, I would review the procedural history, the filing of the accusation, what the accusation encompassed. In short, it deals with negligence in the performance of an audit. In light of the fact that the petition here is on a very narrow, discrete issue that is actually unrelated to the specific allegations contained in the petition, and he's not seeking to terminate probation, I'm not going to really spend any time going over those matters at this time. The board members have it all available in the petition package and can review it and can ask questions as they determine it to be appropriate. A summary of the case is set forth in Mr. Franzella's memorandum, which is found at PET 1 to page 3. That at least gives a brief summary of the matter. The discrete nature of this petition is to reduce the costs that were stipulated to with the respondent from the amount of $5,000 payable during the course of probation down to $1,000 due to the financial condition and employment situation of Mr. Turnbull. With that being said, Your Honor, I would request that the witness be sworn.
All right, before we do that, I actually have another document that needs to be marked and addressed, and those are the memos related to the notice of the hearing that being served and documentation that authenticates those records.
Thank you, Your Honor.
All right, so that's going to be marked as Exhibit 2. And Mr. Turnbull, did you receive a copy of what's in Exhibit 2? Mr. Sinai, did you ensure that he received a copy?
Are you referring,
I believe he has, and he's present here today as evidenced by the fact that he was
All right.
given notice.
There are several documents, so just, I want to make sure that you receive those. Mr. Turnbull?
yes,
All right, any objection then to Exhibit 2?
none.
All right, Exhibit 2 is admitted. And then with that, Mr. Turnbull, I'm going to have you stand. I'm going to swear you in. Please raise your right hand. Do you solemnly swear or affirm, under penalty of perjury, that the testimony you give in this matter will be the truth, the whole truth, and nothing but the truth?
I do.
Please have a seat. And please state and spell your name for our court reporter.
James Michael Turnbull. Spell it. James. Michael, Michael. Turnbull, Turnbull.
All right, Mr. Turnbull, is now your opportunity to provide the board members any information that you want them to consider for purposes of rendering a decision on your request to have your penalty reduced.
Well, thank you for setting up this hearing so I can present my case. To me, it's a matter of financial ability. When I undertook when I signed on to the probation and the $5,000 spread over 2 years, I didn't think it was unachievable. However, I don't know what is going on in the market, but I find it difficult beyond the going through the tax seasons, difficult getting work. And so I had been making staggered payments each quarter based on my ability to pay. I wonder sometimes if people, when they are considering me for employment, checks my CPA license, and they can see that I'm on probation, and it gives a brief outline of the probation, the accusations. It's come up in in 2 interviews I've had, at least 2 interviews, that they brought up the probation issue, and I didn't subsequently get the job. So I'm kind of hammered in one respect. I'm going through a tough period getting employment. I am on unemployment insurance. And then when opportunities arise, I wonder if people check out my CPA certificate, my license. So I'm really struggling at the moment, and I just wanted to make my case to you that I would seek any help you can give me with this regard. So to me, it's a simple issue. I'm trying my best to comply with the order, and I'm just finding it very, very difficult. Essentially, that's my case.
Counsel, any questions from Mr. Turnbull?
Let me just confirm, Mr. Turnbull, that the facts and matters set forth in your petition are true and correct? Is that true?
Yes.
It was not intended to be a trick question. And that you have paid, I understand, $500 to date, correct?
Yes.
Okay. And you're seeking to reduce it from $5,000 down to $1,000, correct?
In total.
In total, okay. I have no further questions at this time, Your Honor.
All right, Mr. Turnbull, it's now the board members' opportunities to ask you any questions that they have, starting to my left, please.
I know it's in here, I just can't seem to find it. When does your probation period end?
I believe it's around February 2019? No. 2020, I think. That's a good question. I should know off the top of my head.
Carl, you remember, was it 3 years or 5 years?
3.
3 years, I believe, Your Honor, Mr. President, and I believe that the stipulated settlement was effective May 1st, 2017, so it'd be May 1st, 2020.
Thank you. No further questions?
What type of work have you been looking for? Has it been with other firms in the tax area or just with companies?
Well, my experience is around tax, and also I have a lot of SOX experience, and I've been aiming. So when it's tax season, that's usually very easy to get work. But come the rest of the year, I'm looking for any kind of SOX position or line management position. And so far, I'm not sure what inhibits me getting it, but I sometimes think it's my age to a certain extent. But it's been difficult.
Okay. No further questions?
One brief question. I notice your license lapsed a few times in recent years. What was the
Lapsed?
reason for that?
I was unaware it lapsed. Actually.
If you look at page JMT PET 055, I believe your certificate expired and was not valid for certain periods of time.
I believe I had a delay going on completing my CPE, and that was basically the reason. Is that just one occasion?
That was the only matter that I saw, just that one episode.
Okay, and I assume you intend to stay current
Oh, absolutely.
on your CPE going forward?
Part of my order is to do 24 additional hours in auditing, which I completed.
Thank you.
Yes.
Hi, good morning. Can you speak to the size of your household and how many financial dependents you have, or is it just you?
My wife and myself, 2 people.
Thank you.
Hi. On page PET 3, you mentioned that you did another audit engagement for June 30th, 2018, but you're not enrolled in a peer review program. Is that going to cause some future problem?
No. The matter is being attended to, and I will be compliant very shortly.
Okay, thank you. Could you pull the mic closer so we could hear you?
Can I see that, please?
Sure.
Yes, what's going on there is essentially it's another cost issue. The peer review itself is going to be around $3,000, and all I'm doing is one audit of a non-profit, and the cost is an issue, but I am determined to address this to get reinstated in the peer review program and do the peer review. So that's my commitment to you. And it's part of my order as well.
Thank you.
Hello, my name is Katrina Salazar. Because this information is submitted well before the hearing, you provided us information about your 2017 financial picture. Can you just confirm that there have been no significant changes since then, January 2018 through today, that would change your financial ability or your request for abatement?
Well, I did bring an updated statement through July 2018. It's still much the same situation. I earned $36,000 in tax fees, and that's basically basically it.
Thank you.
I have no questions.
Sir, in the $500 that you did pay, was that paid for one particular quarter or on a sporadic basis?
It was spread over 5 quarters, I think.
Thank you.
Hi, so you performed a one audit, and it sounds like you're trying to get in compliance with the peer review requirement of your prior agreement. Is it your intention to continue doing audits?
No, I made a conscious decision not to.
So the June 2018 audit that is referenced in the materials is the last audit that you would intend to perform?
Yes.
Thank you.
I'm sorry, was that a yes?
Yes.
All right, thank you. No questions. And did you step in late?
My apologies. My name is Deirdre Robinson.
Thank you.
Thank you.
Right. Right. No other questions from the board? Right. Mr. Turnbull, did you want to submit your updated financial document to the board for consideration?
Well, it's going to be under seal again, is it?
It would be under seal. I would put it under seal, just like I did page 13 of the petition package. But I will mark this separately as Exhibit 3. Any objection to the updated financials, council?
None.
Exhibit 3 is admitted. All right, anything further than, any additional questions, council, before we begin with closing remarks?
None.
All right, and so, Mr. Turnbull, now's your opportunity to give any closing remarks you have for the board.
Well, I thank the board for listening to my petition. I'm really trying to comply with the order as best as I can, and just the basic problem I have is maintaining an income level where I can easily comply with your order. So that essentially is my case. I've had a really difficult time getting employment, and even though it's, yeah, and basically that's my case. Thank you.
Council, any closing remarks?
Briefly, in a case which the lawyers among us call the Zuckerman case, the California Supreme Court has given guidance that cost recovery is not intended to be a punishment. even though it gets described as a penalty, and that in considering whether cost enforcement or cost recovery should be given, one of the factors you consider is the financial ability to pay, so that you do not make it impossible for someone to comply with an obligation imposed by recovery of costs. That determination in the Zuckerman case usually takes place when the matter goes to hearing or by stipulation. I don't know if there's a case on point that has dealt with it in the context of a petition for reduction, but I submit that the principle is largely the same, which is the point of probation is not to punish and to make it impossible for someone to comply with. And so with that point, I would, the only other remark I would make is, while there is evidence before the board about his current status of compliance and performance of duties and his probation, this is not a petition to revoke probation, and there's no allegation before the board that he is violating probation, so I have not raised that issue.
All right, with that, is the matter submitted for the board's consideration, counsel?
Thank you.
Right, and Mr. Turnbull, is the matter submitted for the board's consideration?
Yes.
Yes, all right. The matter is submitted and the record is closed. We are off the record. All right, everyone ready? All right, we're going to go on the record, and I will just briefly announce the case, and then we will get started. All right, good morning. We are on the record. It's September 21st, 2018, in the matter of the petition for reinstatement of surrendered certificate of Dennis Lawrence Dubin. This matter is being heard before the Board of Accountancy, Department of Consumer Affairs, State of California. This is OAH case number 2018-070-241. My name is Marcy Larson. I'm an administrative law judge with the Office of Administrative Hearings, presiding over the matter this morning. We are here at the date, time, and location of the notice of hearing, and there is a quorum of the board present. Deputy Attorney General, please state your appearance for the record.
Yes, good morning, Your Honor, and members of the board. I am Deputy Attorney General Carl Sani. I'm appearing here on behalf of the people of the state of California pursuant to Business and Professions Code Section 5115.
And counsel for Mr. Dubin.
Good morning, Your Honor. Are you able to hear me?
I am.
Thank you, Your Honor. President Savoy, esteemed members of the board, and Mr. Sani, of course. My name is Stephanie Sessions Perkins of the Perkins Law Group, appearing for petitioner Dennis Dubin in connection with his petition for reinstatement of his license or certificate to practice before this board.
All right. And Mr. Dubin is present here, seated next to you, correct?
Yes.
Yes.
All right. Good morning.
Good morning,
So-
Your Honor.
Good morning. So you had the benefit of sitting in the audience for the last hearing, so I'm not going to repeat all of the specifics, but we will have the Deputy Attorney General start this morning and identify the records that are before us and give a brief orientation of the matter. And then, Ms. Perkins, I will turn it over to you to give any opening remarks. I will swear in Mr. Dubin, and then you'll have the opportunity to question him. And then once you're finished, I will ask counsel if he has any questions, and then we'll open up to the board. All right?
Yes, thank you, Your Honor.
All right. So, Mr. Sani, please.
Thank you, Your Honor. I would like to mark for identification and offer into evidence as Exhibit 1 the petition, which included, and the accompanying documents such as the cover memo from Mr. Franzella. And I'll describe the documents in more particular. The number DLD-PET-001 to PET 250, 250 pages. The petitioner and members of the board and his counsel have been given copies of this document. I would like to make one exception to one page out of the 250 pages, Your Honor. And so while I'm offering the whole packet into evidence, I want to exclude 2 or 3 paragraphs as improper. So referring to pages PET 25, where it starts out with heading 7, until PET 26, to where it starts with PET, Roman numeral 8, We're objecting to that coming into evidence on the basis that it is legal argument. It is a characterization of prior board decisions which are argued for the purpose of saying that this matter should be treated the same. And as is customary in cases, none of these decisions had been described or determined by the board to be precedential. And pursuant to Government Code Section, I think it's 11-513, subparagraph F, Your Honor, we believe that the burden of going into each of these cases and comparing and contrasting the facts of those cases to the facts of this case would take an undue consumption of time, particularly when the decisions are not actually even before the board for consideration. They're not attached to the packet. So we object to that as legal argument and improper legal argument at that.
All right, so that's all of the information in Roman numeral 7 on page 25 and 26.
Yes, and I have given counsel advance notice of my objection to this, those paragraphs.
Any response, Ms. Perkins?
No, Your Honor, other than we acknowledge the objection, and we did not submit the material for purposes of asserting that it had precedential value that imposed on this court this board any obligation to follow suit. We gave it strictly as a guidance and as a rule, not a rule of thumb or anything like that, but more importantly to give the board context for similar actions. So I don't respond other than that, Your Honor.
Right. So with regards to that particular information, counsel, it would only be considered as argument, not evidence?
Yes, but the problem is that the argument is based on specific evidence, i.e. decisions of the board, which are actually not in the petition packet. And to properly respond to those cases would require me to not only go into the facts and circumstances of those cases, but also to bring in other cases that the board has rendered that could be characterized as being contrary to those cases or having a different final resolution by the board. And we think it's just a big distraction and undue consumption of time for the board to be misled by a characterization of a limited number of cases.
All right, so your objection is relevance, yes?
Relevant and 11-513 subparagraph F specifically.
All right, so with regards to the relevance objection, I'm going to overrule the objection. It's going to go to the weight of the evidence, and the board members can consider whether or not they want to give it any weight while they're in deliberation. All right, Exhibit 1 is admitted. Is there no objection, counsel?
No objection, Your Honor.
Okay, then let me proceed to describe the petition. The petition itself is found at pages PET 4 to PET 231. The accusation which gave rise to this matter is found at pages PET 233 to 239. The stipulated surrender is found at PET 240 to 248, in which Mr. Dubin admits to the truth of all the allegations in the accusation. Finally, the license history for Mr. Dubin is found at the conclusion at pages PET 249 to 250. Do you like, Your Honor, I can proceed to give a summary of the case, or?
Please do so.
Okay. This matter arises out of, well, let me first say there is attached at the beginning to this Exhibit 1 a memorandum from Mr. Franzella to the board, which summarizes the facts and circumstances. Mr. Franzella's memo is pretty good. I would want to, just for clarity's sake, Your Honor, describe that the cause for discipline as listed here seems to be simply a matter of a criminal conviction. The accusation, however, that gives rise to this petition describes not only a cause of action for conviction of a substantially related crime, but also included allegations of false, fraudulent, materially misleading reports, a third cause of action for dishonest acts, a fourth cause of action for fiscal dishonesty, and a fifth cause of action for a willful violation of the Accountancy Act. And the pertinent facts which gave rise to the stipulated surrender are found at paragraphs 13 to 18 at pages PET 236 to 237. And what they describe is that for a period of on or about 2003 to 2009, that Mr. Dubin knowingly prepared tax returns containing false information. So it was over a period of years, and he conspired to defraud the Internal Revenue Service. Paragraph 14 talks about a Vista Pacific Trust that was created in the Cook Islands with the assistance of the respondent, and with the opening of a bank account in Zurich, Switzerland, held in the name of Southpac trustee. And then paragraph 15 describes how, after the sale of a hacienda investment property, respondent and one of his clients sent the proceeds of over $14 million to the bank account in Zurich, Switzerland, and those were not properly reported. Paragraph 16 describes how the respondent conspired to prepare a partnership income tax return, which falsely reported a gain on the sale of the hacienda investment property, in that he intentionally reported the basis as being $7 million higher than the actual basis, even though he knew that there was no legitimate reason to inflate the basis. And then paragraph 17 alleges that he filed a false individual tax return for one of his clients, and he knew that it was false, and as it underreported the gain on the sale of the investment property sold in the prior described paragraph, the hacienda property. And then finally, paragraph 18 describes transactions involving rental property in New Zealand and false returns in connection with that transaction. And ultimately, Mr. Dubin was convicted, I believe, of 2 felony counts. He cooperated with the government, and I believe he was described as an exemplary cooperator with the government, in which Mr. Dubin in his petition says reduced his potential exposure of 30 years in prison and reduced his sentence to 24 months incarceration and 3 years as supervised release. I think, just for clarity's sake, and I don't think there's any argument, supervised release is the federal characterization of what would be state court probation. Mr. Dubin completed his supervised release, I believe, in February of this year. Under the terms of the stipulated surrender, he was ordered not to file a petition for reinstatement for a period of 3 years, and that 3-year period has now passed, and Mr. Dubin is before the board. I believe that is just an overview of the allegations which gave rise to the accusation, the stipulated surrender, the conviction, and ultimately this petition. The petition has a large volume of documents attesting to the undisputed contributions that the petitioner has made to his community, financial contributions, time contributions in the service of his community, and a lot of character reference letters. I'm not going to go through those and denote the various pages. The board has those before them. And finally, there is a letter from his daughter and husband?
Yes.
Daughter and husband has submitted documentation attesting to his character, as well as numerous friends and family. Thank you, Your Honor.
All right, thank you. All right, Ms. Perkins, I'm going to allow you to give opening remarks. I want to remind you, though, that the board does have the benefit of the petition package. It is quite detailed, and there is a lot of information in there, so don't feel like you need to repeat all of that. Once you give opening remarks, I will then swear in Mr. Dubin, and then you can question him as well.
Thank you, Your Honor, and I appreciate your comments. In fact, having appeared before this board before, it's been my experience that perhaps the best way for this board to make an effective assessment of whether a petitioner is qualified for, should be reinstated, is to hear directly from the petitioner. And so I tend to leave my remarks to somewhat of a minimum, although I would like to clarify just a few points. Before I do that, I'd like to thank again the board for hearing the petition, and we would ask the board, of course, to consider the petition thoroughly in evaluating whether to exercise its discretion under Business and Professions Code, Section 5115, whether to reinstate Mr. Dubin's certificate to practice. I'd also like to thank his husband, Kevin, and his daughter, Chelsea, and his son-in-law, Dominic, for being here with him in support of this petition, because it's been a very arduous process and a long process for this family. And they come here very humbly. Mr. Dubin comes here humbly before the board. I would like, as an officer of the court, to make a slight clarification for the board's benefit, if I may, to the petition. As the author of the petition, while Mr. Dubin certainly will tell you personally, if necessary, that he accepts full responsibility and acknowledges the content, if there's in any way any ambiguity, I'd like to clarify that the petition was in no way intended to suggest to this board that Mr. Dubin in any way abdicates responsibility for the conduct that gave rise to his either conviction or the assertions, accusations, or the ultimate facts to which he acknowledged through his stipulated settlement with this board in response to its accusation that his own conduct, and it does not intend to shift blame to anyone, and most importantly not to James Pfluger or any of his family members for the events that gave rise to either the criminal conviction or the accusation or civil lawsuits that ultimately stemmed from the very same facts that Mr. Dubin found himself faced with criminal action, or a criminal indictment, an ultimate guilty plea for, as well as other facts. So to the extent that this board may have been confused in any way by anything my office or myself personally had submitted, I would wish to clarify that point, because my client does and will explain to you personally he accepts full and complete responsibility, as well as accepts full and complete responsibility for the violations that are asserted in and were stipulated to in connection with the underlying accusation. I would also like to clarify one additional point before I turn the floor to Mr. Dubin, if I may, and that is that with respect to petition, specifically pages 11 through 12, in reference to the civil action settlements, there may be, although I doubt it, I would like to just clarify, if there was any ambiguity or concern that these civil action suits that were filed in or around the 2013 and 14 years, they all are predicated upon, and we understood the board was aware, were based on the same set of factual allegations and were precisely related to and directly related to not only the facts underlying the criminal conviction, but also the facts underlying the stipulated settlement with the board in connection with its accusation. That may have been an ambiguity in the way that I authored this petition Exhibit 1. And so to the extent there is that ambiguity, I accept responsibility and apologize to the board for that. But I wanted to make sure that was clear. And of course, Mr. Dubin is prepared to answer any questions should this board have any relative to that issue. With that, as I said, I feel that perhaps it's best if the board entertains a brief comments from my client rather than me entertaining a direct examination or undertaking, a direct examination of him relative to these events and to his petition specifically, if I may, Your Honor.
Yes, but I would like to swear him in so that all of his statements are under oath. So Mr. Dubin, if you'd please stand. Raise your right hand. Do you solemnly swear or affirm under penalty of perjury that the testimony you give in this matter will be the truth, the whole truth, and nothing but the truth?
I do.
Please have a seat. And please state and spell your name for the record.
Dennis Lawrence Dubin, Dennis Lawrencedubin.
All right, then, Mr. Dubin, it's now your opportunity to provide any testimony that you want the board to consider.
I want to thank the board for hearing the petition and for taking their time today to listen to us. When I was going through the paperwork and Stephanie and I were preparing the petition, it became abundantly clear to me that the most important criteria for reinstatement was for the board to be confident that the acts that I committed would not and could not happen again. And they were serious, and they resulted in prison and in the loss of my license. And we just got through observing the Jewish holidays, and that's when you go to synagogue and you ask God for forgiveness for your sins. And you do this through atonement and repentance. And when they say atonement, they talk about making things right, correcting wrong that was done, making amends for your sins, accepting responsibility and punishment. And when they talk about repentance, they're talking about confession, remorse, and regret. And I have confessed, and I have been remorseful for 9 years over the acts that I committed. But the real definition of repentance is if you are faced with the same opportunities or the same circumstances occurred that led you to commit a dishonorable act or a sin, and those circumstances reappeared, would you make the honorable decision this time, or would you go back to your old way and make the other decision? And I just want to assure the board that were any similar opportunity or circumstance or any event to come before me, I would only make the honorable decision. I would never go back to commit the dishonorable decision. My options would only be the ones that were moral and ethical and under the rules and under the regs. That is sort of the would not happen. The could not happen for me is that the firm that I'm privileged to work at right now has procedures and policies and manuals and checklists and review procedures so that nobody could ever submit a filing or a financial statement or a return that did not represent accurately the facts of the taxpayer client. So both of those would not and could not. I just wanted the board to understand they're not on the table any longer for me.
Ms. Perkin, anything before I open it up to Mr. Soni for questioning?
No, Your Honor, thank you.
All right, then, any cross-examination?
Yes, a few, Your Honor. First, you pronounce it Duban, is that
Yes.
correct? I apologize for mispronouncing it. You mentioned that you are in a firm in which this could never happen again because of the rules, policies, procedures that are in place, correct?
Correct.
How many CPAs are with the firm presently?
2.
And you are a staff member?
Correct.
How many other staff members are there?
About 15.
Okay. Now, I understand that you are a partial owner of the firm,
Yes.
and about a 49% owner,
Correct.
and the remainder of the ownership of the firm is divided between the two CPAs?
No, it's all in the hands of one CPA.
One CPA, okay. And so it's fair to say that you almost control the firm. I mean, you are 1% shy of being a co-equal owner, correct?
I'd object to the question, Your Honor, in that control. I understand that objections are not ordinarily appropriate in this circumstance, but to want to classify it as that or characterize it as that seems highly unfair, and
So-
that calls for a legal conclusion.
Counsel, the objection is directed to me, and
Thank
I'll
you, Your
rule
Honor.
on the objection. And you may make objections to questions, but I just want the objection and the legal basis.
I object to the conclusion, excuse me, the question that draws for a legal conclusion,
All right.
calls for legal conclusion.
All right, so I'm overruling the objection, and Mr. Duban understands the question. He can answer it. Mr. Duban, do you understand the question?
I do.
All right, please answer it then.
So in my experience, actually, having 49% of something is almost like having one, because you can't control a vote. You can't, if the two people, the 59 and the 41, disagree, it's the 51. So I've never felt like I had any control. And my ownership of the 49% was never intentional. May I speak to, what happened when I was going away is Mr. Theodig, who was the CPA at the firm at the time, he offered to purchase the firm. And in addition, my sister, Helene Duban Nishizawa, had worked there her entire adult life since she was 18. So she and Rick purchased the firm from me and kept the doors open while I was away. Unfortunately, in November of 2017, my sister died, and she owned this piece of the firm that my brother-in-law doesn't know what to do with. He never worked at the firm and didn't know what to do, and was faced with his own financial issues and 2 kids. The youngest was 11. So that was when I felt to buy her share back, to give him the freedom to go on with him raising his family and things. That's how I ended up with the 49%. It wasn't intentional or preordained or anything like that.
Okay. The current name of the firm is DLD Accountancy?
Correct.
DLD are your initials?
Correct.
And I take it the reason for that is you're a primary marketing person, or you have a substantial relationship with your clients?
We were looking for continuity, and the clients that have been around for 20 and 30 and 40 years, they know me and they trusted me, so they felt like the new firm, if it had a connection, it would help keep it open, keep all of the people employed, keep the clients available to the services.
Now, if your license were restored and you got your CPA certificate back, how would that affect your actions within the firm?
I think it would impact my the image that I project in the firm. I think that people could see me as a leader again. I think that I bring 45 years of experience to my staff and to the client when they ask questions. So I think that the image would be that Rick could say that both owners are certified public accountants.
Okay. Are you an enrolled agent?
No.
Have you ever been an enrolled agent?
No.
Do you have any authority under CTEC, a CTEC license or registration?
I don't. I'm not sure I know what that is.
California Tax Exchange Council certification?
No.
That's fine. Now, the letter that your counsel has signed, you've also countersigned that letter at page PET 28, saying that you certify the foregoing as a true and accurate representation of the events discussed therein, correct?
Correct.
And I take it you had a hand in drafting or revising the letter so that it comported with your understanding of the matters?
Yes.
A couple questions, actually a few questions just about the letter. By the way, would your ownership change if you got your CPA license back?
I don't know if it would change or not. I think that would be something that Mr. Thiedig and I would have to discuss.
Okay. So I wanted to review some of the matters set forth in your letter. There is a remark on page PET 13 that of blackmail threats, and I'm not sure what those concerned. You also mentioned blackmail threats elsewhere, I believe, at PET 17, paragraph 13. I'm not saying you need to disclose any subject matter of what the blackmail was about, but can you
Yes.
describe anything about that or shed some light on that?
Yes, when I entered into my cooperation agreement to testify against Mr. Pfluger, his companion contacted my lawyer and said that unless I were to sign over certain real estate to her, that her family would approach the judge in Hawaii and make sure that my case came to an unfavorable resolve. And I didn't sign anything over, and instead my attorney contacted the authorities in Hawaii.
Okay, so nothing came of that because the feds were
Correct.
notified.
Correct.
Now, I'd like to turn your attention to page PET 15, which is page 7 of the letter, to the very bottom paragraph. Do you have that?
Yes.
Going to the second sentence at the last paragraph, it says, based on the documentation provided, Mr. Dubin estimated that approximately $50,000 was personal in nature, but admittedly, he did not verify the accuracy of the estimate. Was this $50,000 estimate, was that part of the criminal charges against you?
Yes.
Okay, so was the art, because we don't have the criminal documents before us, are you saying that the mistake, or this was simply an estimation error on your part?
Correct. The CPA in Hawaii was under the year-end deadline, and there were credit card bills that hadn't been coded, and asked me for my help based on the credit card codings that had been done prior year, and I mistakenly recommended estimating it rather than saying you go through the credit card item by item and figure out what's personal and what's corporate.
Okay, and what was the position of the prosecutors in connection with this estimation?
They said that the estimation put too small of a personal nature on the credit card, that it should have been more.
Okay, so in essence, you weren't required to do an estimation, you were required to actually verify what was personal and what wasn't.
I was actually required to tell the CPA there to verify it rather than giving the recommendation that estimating was okay. It was all, they had all of the paperwork.
Okay, I'd like to turn now your attention to PET 16, the next page. Go again to the last paragraph. You see that? It starts in preparing the 2007 return.
Correct.
Okay, it says Mr. Dubin incorrectly recorded and inflated the San Diego land's basis by $6.9 million. You see that?
Yes.
And then in the next sentence, it says the error occurred because the San Diego property was the subject of a 1031 exchange. My question is, by using language such as incorrectly and error, it would seem to suggest that these were just mistakes. Isn't it true that these were actually fraudulent statements that you were making?
Yes, they were intentional. I accept that they were absolutely intentional.
So it wasn't an error, correct? It was an intentionally fraudulent act.
Correct.
Okay. So you would correct that characterization in your letter?
Correct.
Page 17, it's page 9 of the letter, PET 17. Fourth paragraph from the bottom, the government categorized Mr. Dubin as an exemplary cooperator. You see that?
Yes.
And that's true, correct?
Yes.
And you understood that by cooperating, that would enhance your ability to get a reduced sentence, correct?
Correct.
And the potential exposure that you face for the conduct that you engaged in was up to 30 years in prison, correct?
Correct.
And part of that was due to the amounts that were involved in these transactions, correct?
Correct.
Okay, now I'd like to turn your attention to the next page, PET 18. First full paragraph, it says Mr. Dubin was tortured over his decision to plead guilty. You see that?
Yes.
Were you guilty?
Yes.
What was it about pleading guilty that tortured you?
It was the impact that it was going to have on my family and my firm and my reputation.
Okay. Now, in the same page, page 10, PET 18, it says in the second full paragraph that ironically, in a twist of fate, it says that Mr. Pfluger was acquitted of the conspiracy charges, correct?
Correct.
And his son, Alan, did plead guilty to willfully filing his own false Form 1040, correct?
Yes, he did.
Okay, now, I'd like to turn your attention to these civil lawsuits that are described at pages PET 19 to 20. You see that?
I'm sorry, your pages again, Counsel?
PET 19 to 20.
Well, we
It's-
don't have your numbers, so you're
I'm sorry,
talking
page 11 to 12, section 3 of your letter.
Yes.
You have that before you?
Yes.
Okay, I understand counsel has indicated that these civil lawsuit matters derive from the same transactions which gave rise to the federal prosecution, correct?
Exactly.
Okay, let me ask you though, the federal charges that you were convicted of are for a breach of your duty as a CPA to the United States government, correct?
Yes.
What is described in your description of the civil lawsuits are violation of duties not to the U.S. government, but to your clients. Is that correct?
Yes.
Okay, and that involves litany of breach of contract, breach of the covenant of good faith and fair dealing, breach of fiduciary duties, professional malpractice, fraudulent concealment, fraudulent misrepresentation, negligent misrepresentation, fraud, constructive fraud, violation of the Hawaii Unfair and Deceptive Acts Act, violations of the Hawaii Uniform Securities Act, and unjust enrichment. Now, those all involve other independently owed duties to your clients. And I understand from your counsel that we don't have those documentation before us here today. You acknowledge that if you had been a CPA, you would have been obligated to notify the Board of Accountancy of this substantial settlement, correct?
Correct.
Okay, because the settlement occurred after your license was revoked, a period of months afterwards, correct?
Correct. The lawsuit and the settlement.
Okay, and the total amount of the settlement of to the father, Mr. Pfluger, was $2.15 million, which you later compromised for $1.575 million, correct?
That's correct.
And you paid that, correct?
That's correct.
And then with respect to the son, who had also pled guilty to tax fraud, he sued you as well, correct?
Correct.
And you settled for him for an amount of $500,000, correct?
That's correct.
These are, you would agree, are very substantial sums.
Yes.
And you're still paying the son in installments for the amounts that you've agreed to.
That's correct.
I'd like to backtrack for a second to PET 16.
Mr. Sonny, which page are you?
I'm sorry, it's page 8 of your letter,
Thank you.
PET 16. Now, I'm going to have to add up the number of lines. 1, 2, 3, 4, 5, 6, 7 lines from the bottom, 7 or 8, depending on whether you count the last one. It says, Mr. Dubin had no incentive to do this. This is the Hacienda fraudulent basis issue. And in taking this course of action, he paid a very high price. Do you see where it says Mr. Dubin had no incentive to do this?
Yes, I do.
Is that accurate?
It is.
The reason I ask you that is just 4 lines above that, you indicate that you did this, one, so that you would not disappoint Mr. Pfluger, but you didn't want to lose him as a client. Do you see that?
Correct.
So that was, in fact, a pretty substantial incentive in your mind, which was you wanted to retain Mr. Pfluger as a client, correct?
Correct.
And that had been a financially successful client for you, correct?
Correct.
I have no further questions at this time.
All right, I'm going to open up questioning to our board members, starting to my left with the president.
Thank you. Thank you for being here. Assuming you received your license back, you would then have signing authority, which you do not presently have. Is that correct?
Correct.
And while you presently and may continually own 49%, by having signing authority over financials, tax returns, or whatever, how can you assure this board? And I hear about your checklists and your review process, but how can you assure this board that what you do by now having signing authority will not breach the fiduciary responsibilities that you tell us you have and you will forever hold?
I can tell the board that the last decade of my life has been horrible, and that prior to the events that occurred in connection with this family, my record was stellar. Nothing like this happened before that. Nothing like this has happened since. The 9 years that our family suffered in terms of the investigation and the indictment in 2010 and the guilty plea in 2012, and my federal prison term that started in 2014 with solitary confinement, where I was handcuffed if I wanted to go outside and see the sunshine in a cage that was 9 by 12, and got my food through a slot in a door, and had to be stripped and searched every single time my family came, both before and after. I could never put myself through that or my family through that. I was without my family for 2 years. I was out without my freedom for 3 years. I've been out without my CPA license for 4 years, and I've been without my peace of mind for 9 years. I never considered anything like this before this family, and I never considered anything like this after. If anything, I am so much more rehabilitated now than if it never happened. Because if it never happened, you don't know what you would do. I found out that I would do the wrong thing. But now that I know what that can do to you and your family, I know that it can happen. Kevin has stood by me for 36 years. Chelsea got to spend her senior year of college with her daddy in prison, and yet I managed to get the only known furlough from this warden to go to her graduation on consecutive red-eyes. So he understood this was not a pattern. And I can assure you that it's not a pattern. It was a problem that I had in connection with this family.
Thank you. No further questions?
Couple questions. So going forward then, you would anticipate you'll continue a tax practice with the firm that you currently have 49% in?
That would be the privilege that I'm asking for, yes.
Okay. Would that also involve either compilations or audits, or is it just going to be limited to tax and tax consulting?
I do tax and tax consulting only.
Okay, thank you. No further questions?
Mr. Duban, just a brief question. Thank you for your statement, and the board notes the attendance of your family here with you today. My question revolves around your licensure and revocation in Hawaii and the state of Washington. What is the status of that?
I held licenses in Hawaii, Washington, and New York beside my California CPA. I have surrendered all those licenses simultaneously with this one.
Thank you.
No questions.
So currently, what are you doing right now with, since your license is not reinstated, you're doing tax return, and how is the supervision of your work?
I'm allowed to meet with the clients, and we advise on taxes, and then I am allowed to procure their information and prepare the tax return and put together a work paper file. And then that file goes for review, and then after the review, it goes to Mr. Thiedig, who's the CPA, and then he reviews it again, and he's the one that signs it. And then if there are questions or follow-up work, then the client would typically contact me.
Okay, so when you get back signing authority, how would the review procedure change?
In this firm, at the present time, regardless of whether or not the return is prepared by a staff member, a CPA candidate, or a CPA, it has to be reviewed again by either the other CPA or by one of the CPAs if it's a CPA candidate. So if I prepared a return, it would need to either be reviewed and signed off on by Mr. Thiedig or Alfredo Cardenas, who is the other CPA.
Thank you.
Hello, my name is Katrina Salazar. The question that I have for you relates to the other states that you had a licensure in as well that you surrendered. Have you started a process to seek petitions for reinstatements in any of those other states?
No, I have not.
Thank you. No question.
Good morning. Thank you for appearing before us. During the time that the Flakers were your clients, approximately how much of your business practice did that client's business entail? If you could approximate it.
It was about 5% of the revenue.
Right. Thank you. I have no other questions.
Your Honor, may I ask two brief legal questions to Mr. Asani and Ms. Perkins? Just in case they disagree, I'd like to.
We'll take it question by question.
Okay. It seems like owning part of an accountancy firm, there's no question about, that's legal, is that, do you both agree to that?
A non-CPA can be a minority shareholder in a CPA firm.
Thank you.
Yes.
I also see where.
My understanding.
I also see where he is the chief executive officer of the firm. Is that also allowed?
And again, we're just asking, so just so we can clarify the board members' questions, is we're going to frame them in your opinion, right? So this will be an issue that the board will be discussing in closed session. At this time, he would like both of your opinions and positions on this issue.
Yes,
right.
from their legal opinions.
Right.
Well,
Mr. Sani.
And I'm being extemporaneous here. I have not studied that specific question. I would personally calculate that the purpose of allowing a CPA, a non-CPA to be a minority shareholder is so that that individual does not control and direct the actions of the CPAs in the firm. If he is a CEO, you probably have to examine what authority he has as CPA, as a non-CPA CEO. I don't know what those responsibilities might be. Maybe the CEO looks over the firm's investments. If it dealt with directing the affairs of the firm and other CPAs, I would want to think carefully about how I would view that.
And Ms. Perkin, you can also respond to that.
Thank you, Your Honor. If I may, Mr. Jacobson, we have looked at the issue, and although, again, it's contemporaneous to a degree in that I was not prepared to address the legality of the question you've raised, we did examine it and are comfortable that a non-majority or a minority interest holder, even if they're not a CPA, can serve in a position akin to a chairman, which is our understanding of what Mr. Duban's role is as chairperson, not necessarily a CEO per se. And also that, and you're welcome, of course, to ask him questions directly. I don't want to testify for him, that in this very small and closely held corporation, that he is not a sole decision maker, but that its decisions made regarding the management and operations of the firm are made through the direction and under the control and vote or decision-making of a joint enterprise with the actual majority interest holder.
Thank you. Mr. Duban.
Can I interrupt for a second?
Sure.
This is specifically dealt with the Business and Professional Code 5079 that states non-CPAs, non-licensed owners of firms, except as permitted by the board, a person may not become a non-licensed owner or remain as such if the person has either been convicted of any crime that includes dishonesty or fraud under the laws of any state or any other jurisdiction, and had a professional license revoked or suspended for reasons other than non-payment of dues or fees. So the question becomes, did you seek permission from the California Board of Accountancy before you purchased 49% from your sister's estate?
I'm certain that we did, because the individual in charge of the license at the firm, he is required to submit the ownership documents, the names and pertinent data for the owners of the firm when the license is renewed. So my best recollection is that he would have done that when he filed the most recent applications.
All right, I mean, that's a fair answer, but I didn't want to, for you to give your legal opinion when there is a specific, point on.
I was going to say, I would amend my legal opinion to conform with whatever 5079 says. I say that somewhat facetiously, but it is an issue that's addressed specifically by a statute, obviously. I have not examined it in the context of this case, nor do I think we have any documentation of compliance or non-compliance before the board with this provision.
Ms. Perkins, do you have any response to what has been said?
That I regret that we didn't address it in the petition, I will say that, as the legal counsel, and that it was our understanding, although again, I don't profess to testify here as a witness, that Mr. Duban's office had clarified and notified the board of his conviction and also his interest, his minority interest, implicitly believing that that the board was aware and had approved it. So that's the best I can offer, Mr. Jacobson, and with a bit of egg on my face in that respect.
Mr. Dubant, do you have any authority over the CPAs in the firm?
I don't. I don't have authority in the firm. I can't sign checks on the bank account even, so I don't. These are not policies that the staff put together where I could circumvent or where they could circumvent that. These were meant to be foolproof and bulletproof so that nobody, whether it was the lowest or highest person on a totem pole, would ever be able to put something through that wasn't correct.
Do you have authority over their compensation?
No.
Thank you.
All right, moving to the right. Any questions?
Yes, you mentioned you don't do, have you ever done audit or a test work?
No, the firm never did audits or reviews.
Oh, so not just, you personally have not, but the firm also has not done any?
Correct.
Audit or test work. Okay. And then, following up on the prior questions on process, and you mentioned, checklists or review processes. Is it my understanding then that those processes exist today, but they did not exist during the time that these prior tax returns or the underlying allegations of the criminal piece, that same process did not exist back then?
We had processes in place, but as the head of the firm, I was typically the one that was able to check the boxes. So I have people that have been at the firm 10, 20, 25 years, but the returns ended up on my desk. Okay. And so in that return, nobody else looked at it, and that was why nobody else from the firm was investigated or had anybody to answer to in connection with this, because they didn't participate.
And should the board consider reinstatement of the license, or I would presume you would be open to probationary periods and terms?
Absolutely.
And probably inclusive of this latest issue that was raised around, who could serve in, what ownership and what leadership positions within the firm.
Correct.
Thank you.
Hi. My only question is, describe your role and responsibility as a non-CPA CEO.
Okay, what I tend to specialize in is not only the tax compliance and preparation of returns for the clients, I also counsel them in financial matters, in estate and gift planning, and in general business planning. I've been exposed to a lot over my career, and I also attempt to be the person on the front line when somebody approaches the firm and is interested in using our services. Typically, our firm is word of mouth growth. We don't advertise, we never have. And so if people are coming to the firm, they're coming because they've heard good things about us. So my role is usually to meet with them when they express interest in the firm.
And may I ask one more question, please?
Speak to the mic, teacher.
Oh, I'm sorry. Oh, that's much better. My question is, do you plan on regaining your license in the other states where you were previously licensed, even though you haven't made the attempts to do so?
I'll be quite pleased with the California CPA license.
Okay, thank you.
Sure.
Yes, we're going to loop back around to the left if there's any additional questions.
Thank you. As the CEO currently, or chair of the firm, do you make any decisions about administrative procedures or any of the other kinds of policies of the firm in your position now, in your capacity now?
No, I'm not doing that right now.
If you were to regain your CPA license, would your status as a decision maker in regards to those matters change?
I hope so. I really do.
All right. Thank you. I have no further questions.
All right, any further questions from our board members? No. Any follow-up questions, Mr. Soni?
No.
All right, any additional testimony from Mr. Dubin?
Could I just say one thing in closing?
Please.
I am so not concerned with ownership of this firm that if there was any such restriction put on the license, or if we find out that I'm actually not even eligible, that's totally fine with me. My singular wish is to be able to practice accounting as a CPA. Once again, it's not about ownership, it's about the responsibility and the ability to benefit my clients and do great work for them that I have done for over 40 years. So it's the license that's at stake here for me today, not owning shares in a company. My daughter's husband wants to be a CPA with a postgraduate degree in taxation, and I want to be the leader and mentor guy that my son can look up to. And that is important to me. When our family decided to embark on this whole petition, we knew the upside. The upside is I could end up with a CPA license again, which would change my life, extraordinarily change my life. And you appreciate something sometimes a little more after it's been taken away because you tend to take things for granted. But I also knew of the cost. We had to relive the accusations. We had to relive all my errors in judgment and my lapses and my crimes and my experiences. We had to go back and ask for more letters and fill out forms and be here today and testify. And that wasn't an easy decision to make because you want to put these things behind you, and they, for some reason, they never are behind you. They're always in front of you. I never let a client come into the firm who doesn't know this history. I never want a potential client or a new client to find out on Google about this. I tell them up front, and if that makes a difference, then I understand that that is another time I am going to pay the price for what I did. But I also knew that with the pain, then suffering, if we had a way out to say, I have my CPA license again, that says a lot. So when it all came down to it, there was a cost, but then I had a shot at getting my old life back in a good way and doing the good things about that life that I did. And I just didn't want to throw away that shot.
All right, anything additional, Ms. Perkin?
Mr. Dubin, if you were to resume practicing as a CPA, would you intend to continue disclosing to new clients, to the firm, to the extent there are new clients, that you've had a conviction and also revocation of your license?
Yes, I do. I want that disclosure and I want that transparency because I don't want them to find out from anybody else.
And if I may, Your Honor, I have a question, Mr. Dubin, with regard to your cooperation with the federal government in connection with its prosecution of James Pfluger. When you testified against in Mr. Pfluger's trial, did you in any way attempt to implicate him with regard to the basis issue with respect to the Hacienda property and your decision to falsely inflate that basis?
No, he had no implication. It wasn't his decision.
And you did not implicate him, correct?
Absolutely not.
And you may remember that earlier in your testimony, counsel, Mr. Sani, walked you through some of the wording and the language in your petition, and specifically the use of the word error on a few pages. Do you recall that?
Yes.
And Is it your testimony or your belief, Mr. Dubin, that the use of the word error in this document, to the extent you assisted in its authorship, was in any way an attempt to understate or understate your conduct?
No, if I use error, I'm talking about error in judgment, error in integrity, error in honesty. I didn't mean that I made a mistake when I was inputting the basis. My error was going there.
So you're not suggesting that you made a mistake as opposed to made an intentional decision to misrepresent to the taxing authorities?
No.
Okay. And then finally, if I may, on page 8 of the petition, and forgive me, Counselor, I don't have the number of the exhibit, it would be page 8 of Mr. Dubin's petition.
PET 16.
PET 16, thank you. One of the, Mr. Sani had asked you a question with regard to whether or not you were induced or felt induced to, I believe that's the word we used, to undertake the action specifically with regard to the hacienda sale, with regard to Mr. Pfluger's tax returns. Do you recall that?
Yes.
What did you understand was meant by and what you intended to mean by use of the words not induced, or there was this error, this not mistake, but intentional misconduct?
Mr. Pfluger never requested that I understate the gain. He never requested that I understate the tax that he owed. This was a decision that I made because his friendship and respect and gratitude for my work, given who he was something that I couldn't handle properly at that time. And it was me, instead of going to him and saying, you owe $1 million in tax, I decided to try to fix it. I decided to try to help him. I didn't help him. I hurt him, and I hurt everybody that was impacted by that decision. But the inducement was to acknowledge the gratitude he felt for me and the respect he felt for me, and that was the wrong way to do it.
I was wrong, Your Honor. I do have a follow-up question, if I may. With respect to the allegations that were brought in connection with the civil actions against you, was it your understanding that, as we talked about earlier, that those were predicated on the same facts as the stipulated settlement in connection with the Board of Accountancy's accusation against you?
That's exactly correct. I know they have a laundry list of complaints that the council described and all those breaches, but the examples in the complaint were exactly the examples that the federal government used when they charged me. There were no other items in there. There were the erroneous returns, the fraudulent returns, and those items. The civil actions didn't bring up anything other than what I had pled guilty to, the logic being from their attorneys, if he has already pled guilty to these items and we sue him, there's not much of a defense. And that is why we agreed to settle those lawsuits.
Mr. Dubin, did you actually dispute those claims against you, or was it strictly a matter of determining the damages they were seeking in the civil cases?
Correct. We did not dispute any of the claims. It was the damages that were the discussions between the two law firms.
Thank you. I have no more further questions, Your Honor.
All right, Mr. Soni, any follow-up?
Yes, and one other matter, Your Honor. This issue about the non-CPA ownership of the firm has now been raised here. Mr. Dubin, are you saying that your firm has complied with that obligation or has not complied, or you don't know?
I'm saying I don't know, but that my understanding was that they had complied because they disclosed me as an owner on our license application.
Your Honor, if I might request a short break, the board can, frankly, determine whether or not that transpired. I could call some staff member if they can develop that information in the next few minutes. I think they're already trying to do it. It's relevant and pertinent because it's potentially a significant issue that goes to the heart of the petition and the underlying organization of his firm.
Any response, Ms. Perkin?
We would agree, Your Honor.
All right, then. Any objection, President? Thank you. All right, we'll go ahead and just take a short, how much time do you think that's going to be needed,
I'm hoping
Counsel?
in the next 10 minutes.
10 minutes? All right, then, let's go ahead and
We've been
take-
going for a while.
Let's take a 10-minute recess then, and we'll come back and have that issue addressed to the board. Off the record.
On the record, what was the break?
We'll go ahead and go back on the record, though. So back on the record, and Mr. Sonny, you were going to give us an update about the status of finding out if the board had any information about the status of Mr. Dubin's position at the firm.
Yes, Your Honor, and staff was hustling really quickly in the short few minutes that they had, and what I think I can fairly represent without having to call any witness to the stand is we can't find information that shows that it has been done, can't find information that shows that it hasn't been done. It's just not a process that can be done in a few minutes, and so we would not feel comfortable putting someone under oath saying it hasn't been done. We haven't found documentation that it has. They can't rule out that it hasn't. So.
All right. And do you have any different information, Ms. Perkins?
Excuse me, Your Honor. We don't have any additional information, Your Honor, other than Mr. Dubin's willing to provide testimony to the best of his understanding with regard to process to perhaps explain further his prior testimony, process within his own firm with respect to renewal of the firm's license, if that would be helpful to the board.
I believe it would be. So if you would please provide that information. And Mr. Dubin, I want to remind you that even though we took a break, you are still under oath.
Yes, I understand, Your Honor. The way that I understood the process at the firm is that there's a form that has to be filled out each year to renew the firm's license. And in between the time that my sister died and the license renewal, and I became an owner of the firm, it was my understanding that that information was disclosed on the license, although I haven't talked to anybody at the office. But the reason that I'm certain that it has is because those are the same documents that are required by the E&O company. And unfortunately, when we did that transfer, nobody was aware of what that would do to our eligibility to secure errors and omissions insurance. And it was a battle to find a company that would insure the firm now that with the record of one of the owners. So it as I recall, quadrupled the premium and cut the coverage in half. But at least there's a policy in place. So my inclination is to know that all of these things were disclosed because of the horrific costs that the firm incurred because of the disclosure. But again, we'll also circle back to see if we can find anything.
All right. Any follow-up questions based on that testimony?
Well, Your Honor, the burden of, I don't want to go to closing, but.
Well, we're going to be going to closing shortly.
Then I can deal with this in closing, I guess.
All right.
As well.
My question to you, is there any additional questions for Mr. Dubin?
I don't have any additional questions.
All right. Any additional questions from the board based on this new testimony? No additional questions?
Yes. Mr. Sani, is this something that the staff will be able to find out, not in 10 minutes, but in some time?
I don't want to make representations on the record as to what staffers couldn't do. This was a very peculiar turn of events, and I would not believe it'd be appropriate to put a staff person here to testify without having, a very comprehensive, review. To my perspective, it's a reasonable issue that's been raised in the proceeding, and the burden would be upon the petitioner to establish that this has been complied with, and then we could vet whatever document they say describes the exercise of discretion by the board. I can't even tell you whether or not that's a staff function to exercise discretion, or whether really that is a board petition matter to get secure permission to be a non-licensee owner. This is a very unusual fact pattern that we're in presently, and I just can't on the spur of the moment make representations about what the staff could or couldn't do in a way that I would feel would be appropriate.
Thank you.
Just for the record, are companies every 2 years renewal, the same way that licensees are? So therefore, this may not have even come up because I'm not sure of your renewal process and the timing of such. So it's an every 2-year process to renew a firm's license. So depending on when that happened, you're required to disclose that on the next renewal. Have there been any changes in ownership? Can you describe such? So while you may have been an owner on paper, it may not have come up yet in terms of the renewal process to the board. So we'll have to find out the renewal date and things of that nature. So that's not an every year process, it's an every 2-year process.
I understand.
So just so, for the benefit of the board members and the parties, the board can only consider for purposes of issuing its decision today, the testimony that's been presented and the documents that are in evidence. So the board does not have the ability to conduct any outside research on their own. So when we go into closed session, all the board will be considering is what's before the board today. Just so you understand that there won't be any outside research that's going to be conducted and presented to the board. It will just be the documents and the testimony. And with that, I wanted to also just address the documentation that Mr. Soni provided to me that was the notice of hearing in this matter also. I neglected to mark that as an exhibit. That is Exhibit 2, and that will just be admitted for jurisdictional purposes. With regards to the notice, but there's also some certifications in there. I'm assuming, Ms. Perkins, you've seen those as well.
Yes, I have, Your Honor.
Any objection to those?
No objection.
All right, then Exhibit 2 is admitted. All right, if there's
Your
no...
Honor, are the parties allowed to ask for continuance based on this?
That would have to be offered as a basis to continue this. That would mean that the board would not be considering the petition, making a decision on the petition today, but rather would have to come back at a later date to present that evidence if Mr. Dubin counsel wants to make that request. And then that would then be up to the board to determine whether or not there's good cause to continue the hearing into a new date. Since Mr. Dubin's represented, I'm going to let him have that discussion with his counsel, and that will be up to...
May we have a short, we can stay where we are, short recess, just to talk with my client for a moment?
That's fine, but we're going to go ahead and go off the record, but I will allow you to step out to do that. All right, off the record. All right, we are going to, back on the record. All right, back on the record. And so Ms. Perkins.
Yes, Your Honor, and thank you, board members, for your indulgence while we navigated through this unexpected twist of events. Subject, of course, to the board's approval, and of course, I don't know what they would say, we would ask for a 30-day continuance, perhaps to the next board meeting, to allow our client to investigate and to provide evidence, as it is his burden of proof, that in fact the board was on notice of his ownership interest. If not, Mr. Dubin is prepared to testify himself that he would, to the extent it makes a difference to this board, immediately divest his interest in the firm. He didn't acquire it other than because his sister passed and it was an urgent circumstance. It had exigent circumstances. And it isn't obviously something that he needs to do in order to pursue this petition.
All right, so with that, this would be a matter that the board is going to discuss and consider in closed session. Any response from the Deputy Attorney General?
Your Honor, I've indicated to counsel that I neither support nor oppose the granting of a continuance. I mean, I never want to deprive somebody of the ability to offer evidence if they think that there's some pertinent evidence they want to offer. I shouldn't say never. There are times when I object to these things, but you know, I don't want to be an impediment in the process. If the board wants to continue this, it would have to be to the next board meeting. Is that here in Sacramento in November?
It's in San Diego.
San Diego? I don't know how that.
I know you're not going to like that.
I might have to walk 3 blocks. But I don't know how that impacts your Honor's responsibilities, having been assigned here on this case. And so
Well, I'm not worried
I
about
have no-
me, so well, that's for the board to consider, as I mentioned in closed session. As far as the logistics, that's something that can be addressed if the board chooses to grant that request, and that will be considered in closed session. Right. Then with that, then, Mr. Dubin, I am going to go ahead and allow you to give any additional testimony addressing the issue that was raised by your counsel concerning the issue of divestment, if that is in fact an issue that you want to address for the board before we begin with closing remarks.
No, I totally agree to that. If divestiture is an option, then I'm willing to go that route.
All right, then. Any additional questions from our board members then? All right, then. Because petitioner has the burden of proof, Ms. Perkins, I will allow you to give closing remarks first.
Thank you, Your Honor. And I'd like to thank the board again for taking the time to hear this petition and for indulging us during the delays related to this unexpected issue that arose. I do represent on behalf of Mr. Dubin and his firm that that he was under the belief that the board was aware of his ownership, but we do also defer to Mr. Savoy's or President Savoy's comment that it could be a timing issue. We have to investigate that in good faith and do not want to make any misrepresentations. Aside from that issue, of course, Mr. Dubin having stated, and he does stand by his position that he would divest any and all interest in the firm, and if that was the board's wish, if it was willing to proceed, we do encourage and actively request the board to undertake and consider this petition if, in fact, the board decides that a continuance is not appropriate or in the public's best interest. Mr. Dubin does not, in our assessment, and we hope the board would agree, present a threat or a risk to the public or to the consumers who this board is charged with protecting. And indeed, his complete remorse and his penance, so to speak, for his prior crime and also for the conduct that gave rise to the accusation against him by this Board of Accountancy, as well as the stipulated settlement and his cooperation and surrender of his license are indicative of his acknowledgement and full acceptance of responsibility for his conduct. And again, just to be clear, he does not abdicate or attempt to in any way subordinate his responsibility to a third party, including his clients. And he's also, interestingly and as anecdotally, some of you may or may not be aware, I'm also a professor of accounting, ethics, and decision-making at a number of state universities, including Sacramento State. Mr. Duban has offered to assist in the development and assistance of curriculum with respect to ethics and decision-making. I know that's an anecdote, but I thought it might be worthy of consideration that he is willing to devote his time both to that endeavor as well as to other endeavors and undertakings relative to training future and present CPAs with regard to their ethical duties and obligations as the future leaders of this profession. It's important to me, and I'm very careful about the clients I take. I have very strong feelings that this petition is well-intended and it should be granted. However, we do acknowledge that there is this one issue, and we will take whatever action this board deems appropriate to assure you that Mr. Duban and his firm remain in full compliance with all Board of Accountancy regulations, irrespective of whether his petition is granted today or not. And for that, with that, I thank you for your time. And if Mr. Duban, if he may, Your Honor, if he has any closing comments, would that be permissible?
If he has anything in addition to add.
No, I'm good. Thank you.
Thank you. All right. Mr. Soni, any closing remarks?
Yes, Your Honor. First, as to the divestiture proposal, I'm not sure actually how that could take place. If the board grants his petition for reinstatement, then he's a CPA, and I would think the non-licensee issue kind of evaporates. If the board denies the petition, whatever obligations he had before, whether not to even be an owner, are still present. And if he had an obligation to divest because he didn't comply with 5079, then that obligation would continue unless there's been compliance with the statute. So the offer of divestiture to me is not meaningful. Let me address a certain other area. They mentioned this as being the main wrinkle, and I admit that I did not see this issue as I was reviewing the materials. To me, but let me even go back one step. To me, I do want to remark that Mr. Duban has submitted abundant evidence of his contributions to his social community, that he, all his friends, families, organizations that he belongs to, that he has genuinely been a charitable person. He's contributed to the lives of many people. I think he has submitted a heartfelt and very genuine and powerful letter from his daughter, showing what a tremendous father he is and husband that he is. And I don't want to overlook the fact that there's been substantial evidence that's been presented to the board that in his social walk of life, as opposed to separating it from his professional life, that he has been, a remarkable person. On the counter side of the character established by those letters and documents is the fact that this was not an isolated instance, that this was a pattern of conduct that occurred over several years from apparently a very valued client that he was willing to take, in his own words, extreme measures to satisfy and to keep as a client. And that is, concern. A lot of the submission, his testimony in the form of the letter, seems to explain a lot, perhaps using verbiage that seems to minimize his own culpability, and yet his culpability is pretty plain. And when you read through the description of the civil lawsuits, and they talk about how, I believe, I thought this was going to be a characterization of a lawsuit that was, frivolous, and then you see the settlement amount of $2 million for one, discounted to $1.57 million, and $500,000 to another parties. These are very significant settlements. And the statute that the board has in place to report substantial financial settlements allows the board then to be given notice and to conduct an investigation as whether or not the conduct warrants its own disciplinary matters. It's one thing to defraud the government, but if he was concurrently defrauding his client on the subject matter of, we don't have the documentation for what transpired in this whole civil settlement, you can't evaluate whether these are additional wrongs, even if they arose from the same client relationship, that would warrant additional scrutiny. So I don't think the burden of proof has been met by the simple characterization of these being the same matter as the federal conviction. Under the applicable law that we deal with in petitions for reinstatement, the burden of proof to establish rehabilitation is on the petitioner, and it's by a burden of proof of clear and convincing evidence. And to me, the leading case on dealing with petitions for reinstatement is a case called Flanzer, F-A-L-A-N-Z-E-R versus Board of Dental Examiners, 1990-220 Calap 3rd, 1392. And that case deals with the fact that what is most pertinent in evaluating whether there has been rehabilitation is to see what's happened after revocation of a license. That is the interim between revocation and the petition for reinstatement. And you look at that in order to balance whether or not the clear and convincing evidence of rehabilitation has been established. And for, as I look through this, to me, the unanswered question is, the civil settlement happened after the board had revoked his license. So the board was not given notice of that, and we don't know what, in fact, the allegations of that amounted to. And those obligations to pay those settlement amounts are continuing. They continue to the present day and go for another couple years. So that's a very substantial matter that raises the question of what, in addition, is going on here. Maybe it is as Mr. Dubin characterized, but the amounts are so substantial that it would warrant examination. The board actually has jurisdiction to conduct investigations and to pursue matters even once a person is revoked. Under Business and Professions Code section, I believe it's 5109, even the fact that someone has surrendered their license does not deprive the board of its power to go after a licensee or former licensee for misconduct, which comes to the attention of the board. And the reason for that is obvious. If someone surrenders their license for doing bad act A and then a year later does really bad act B and then seeks reinstatement, if the board doesn't know about the bad act B, they may reinstate someone who in the middle may have engaged in insider trading or other significant malfeasance. That's why the burden of proof is so important in a case like this. Clear and convincing evidence is not just a characterization of documents and events, it's evidence. And I submit that there are questions here, apart from the 5079 issues, that warrant examination. Now, if the board continues this matter, perhaps Mr. Dubin will provide additional evidence, and maybe the staff will want to examine these issues. But as we sit here today, that evidence is not before the board, and I cannot comment on it one way or the other. Thank you.
All right, since petitioner has the burden of proof, then petitioner gets the last word. So anything additional, Ms. Perkins?
Thank you, Your Honor. We believe that Mr. Dubin has met the burden of proof with respect to the basis on which the petition was originally submitted. We do, of course, defer to the board's judgment with respect to how to address the 5079 issue, as we acknowledge that we did not address that in our petition. With respect to the Flanzer case, we also acknowledge its existence and do not deny that this board has the ability. We would not object to the fact that the board has the ability to investigate a former licensee once the licensee has surrendered his license. Mr. Dubin would acknowledge that he, in retrospect, would have and perhaps should have reported the settlement, but it would be quite ironic, and we believe that we have met the burden of proof relative to the fact that there's a direct and tangential tie between or tether between the civil lawsuits, despite the fact that the complaints are not attached to the exhibit, and the allegations there as related to the Board of Accountancy accusations and the ultimate stipulated surrender. It would be ironic were this board to reopen an investigation relative to a matter that it settled with Mr. Dubin some years ago in connection with the stipulated settlement. And while I acknowledge, as I said, counsel's comment that he does not have the complaint in front of him as an exhibit to our submission, it's quite evident from the facts as asserted and pled by our papers and our petition that that indeed is what occurred. And the timing is not left unaddressed in that the lawsuits were filed even before the accusation was filed by this board. So it's quite clear that that was on the table at the time. But I thank you, Your Honor, and the board for its time and consideration. And we will, of course, submit to whatever decision is made with respect to either the continuance to address this and/or the other issue. Excuse me, I forgot one thing. Mr. Sani had mentioned perhaps if the board were inclined to continue this in relation to the 5079 issue, perhaps we submit additional papers or information, excuse me, since I don't want to send you more writing. You don't want another Stephanie Perkins document with respect to the underlying accusation and settlement with respect to the civil actions. We would most certainly welcome a board inquiry request for that information if you deemed it appropriate.
All right, is the matter submitted for the board's consideration?
So submitted, Your Honor.
All right, matter submitted. Mr. Sani.
Yeah, I was going to interject one comment if I could. It's not important, but I think there's a misstatement of a legal matter there.
What's the misstatement?
Well, I think Ms. Perkins said that the civil matter, because it was filed, was on the table when the board revoked the license for the criminal matters. And I don't think this is like a civil settlement where everyone releases each other. And I don't think they claimed that they gave notice of the filing of the lawsuit. So I don't think that was on the table at the time of the original stipulated surrender.
Ms. Perkins, is that an inaccurate representation?
It's our belief, Your Honor, that the board was aware of the civil actions. The settlement, we acknowledge, was not reported because Mr. Dubin believed that since his license had been revoked and the board had already surrendered his license in connection with the very same allegations, that it didn't stand to reason that a reporting was necessary. I acknowledge I personally, of course, was not counsel at the time, so I can't speak to that. If you'd like to hear from Mr. Dubin on that subject, we're happy to submit additional statements, but I believe, Your Honor, we've made our point on that.
All right, anything further, Mr. Sani?
No.
Is the matter submitted?
Yes.
All right, the matter is submitted and the record is closed. We are off the record. All right, I have the court.
Okay, we're back on the, we're back on the record. We're going to close for lunch for 1/2 hour, so we'll be back at 1:15. Thanks. Okay, we're back. Okay, we're back. All right, welcome back to the board meeting. We're going to pick up where we left off yesterday, which would be my report. Item F, the discussion of the process for the annual officer elections. At our November meeting, the CBA will elect a new president, vice president, and secretary treasurer. The president, vice president, and secretary treasurer serve one-year terms and may not serve more than 2 consecutive terms. The upcoming year will require significant time and participation from the leadership as the CBA undergoes the sunset review process. Leadership will attend meetings with the Department of Consumer Affairs and participate in mock hearings that will prepare them for providing testimony during the sunset review legislative hearings, which is anticipated to occur next March or April. Further, leadership will also be requested to attend meetings with the legislature, focusing on the members who serve on the Senate and Assembly Business and Professions Committees. CBA members who wish to be considered for leadership positions should submit a statement of qualifications to Allegra, the executive secretary, no later than October 4th. Item G, the discussion of the process for the executive officer evaluations. Each year, the CBA president and vice president issue a performance evaluation to the executive officer. This evaluation will be based on input from all CBA members. Members should complete an evaluation form, which is included with this agenda item and will also be sent electronically by staff next week. The form offers feedback regarding the executive officer's performance and will be used during a closed session discussion at the November meeting. During the closed session discussions, members will have an opportunity to discuss the completed evaluation forms and finalize the performance evaluation. I ask that each board member please complete the form and email it to me directly no later than October 12th, please. Okay. Item J, the update, discussion, and possible action on legislation which should affect the California Board. Mr. Bone.
Good afternoon, Mr. President and members. The purpose of this agenda item is to present the current status of legislation that the CBA has taken a position on this year. No action is required on these items. Among your hand carry items today is an updated version of the legislative tracking chart, which replaces attachment 1 for this agenda item. This chart contains all the bills the CBA has a position on, including any signatures or vetoes by the governor as of yesterday. Staff recommend the CBA maintain its current position on all these bills. One exception is Senate Bill 715. Because it was amended and now relates to air quality, it is no longer relevant to the CBA, and we will remove it from our tracking sheet. I would like to point out that the governor signed Senate Bill 1492, which contains 3 minor updates to the law that were requested by the CBA. Also, Mr. President, as was, I believe, discussed briefly in the MSG meeting yesterday, I'm pleased to report that the governor signed Senate Bill 795, which makes permanent the CBA's mobility program. CBA staff, along with representatives from Cal CPA and the national firms, spent many hours throughout this year working with the legislature to finalize the language in the bill and answer questions about the background and purpose of this important program. Fortunately, consumers will continue to benefit from this now permanent program, and we're grateful to all who contributed towards this successful outcome. Finally, Mr. President, I want to touch briefly on our lobbying efforts regarding Assembly Bill 2138, which would restrict our ability to consider an applicant's history of criminal activity and unprofessional conduct. With the exception of certain serious felonies, this bill generally prohibits a board from considering any crimes committed by an applicant more than 7 years prior to the date of their application. Since my report on this at the July CBA meeting, staff continued to press our position with the legislature and the governor's administration. In response to the proponents' claims that licensing boards are inappropriately denying applications for licensure, your staff developed a fact sheet showing that over the past 5 years, the CBA denied about 0.1% of our applicants who have a criminal history. I had numerous discussions with legislative staff to express our concerns and discuss our proposed amendments, although ultimately the bill was approved by the legislature and is now before the governor for his consideration. However, due to our lobbying efforts, we gained some helpful amendments to the bill. For example, 1, the effective date of the bill has been delayed until July 1 of 2020, giving us time to draft regulations and adjust our procedures. 2, the CBA and only a few other boards were granted rulemaking authority to add certain financial crimes that would also not be subject to that 7-year limitation. Now, we have some concerns with how that authority is worded in the bill, but we hope to address that through the sunset review process if it's signed into law. And third, the bill includes language that seems to state that for applicants who were incarcerated for their crimes, a licensing board has 7 years from the date of their release rather than 7 years from the date of their conviction to consider that criminal history. If signed into law, the author of the bill and their staff have expressed a willingness to work with boards to implement the bill effectively, and we plan to take them up on their offer. These amendments are substantive improvements to the bill, Mr. President, so even if it is signed by the governor, I think we should be pleased that our efforts were fruitful and had a positive impact. This concludes my presentation. I'll turn it back to you.
Letter K, developments since February 2015 Supreme Court North Carolina Board. Ileana?
Yes. I have a very brief update. In July of this year, a U.S. representative in the House of Representatives introduced a bill that would protect boards and board members from antitrust litigation. So there hasn't been any changes since July. But just so you know, it's out there, it's pending, it looks good. It looks good if it gets adopted. So for now, I'm gonna leave it at that unless you would like some details just for brevity.
Questions at all? Thank you. I see we have no Vice President's report. Good job. Moving to Mr. Silverman for the Secretary Treasurer's report.
Thank you, Mr. President. I'm pleased to present agenda item 3A, which is the year-end financial report for fiscal year 2017-18. There continues to be technical issues with the statewide implementation of FisCal, which have delayed the timely receipt of all financial reports throughout last fiscal year and continuing this fiscal year. As a result, the 2017-18 year-end financial report is based on preliminary fiscal 12-month figures that were received in mid-September. The Department of Consumer Affairs has communicated that the final 2017-18 year-end statements, including fiscal month 13, are anticipated to be distributed in March 2019. The CBA's fiscal year 2017-18 budget was $14,089,000. This includes a mid-year augmentation of $154,000 for potential attorneys general office expenditures. The total expenditures for fiscal year 2017-18 shown on page 2 were approximately $13.3 million, a 4% net decrease from the previous year. The following are some highlights of the CBA's expenditures. Temporary help, line 4 reflects the CBA expended $360,000, which exceeded its budgeted amount. Temporary help is essential to CBA operations. CBA continues to work with DCA and other control agencies to obtain the resources needed to address the permanent and ongoing workload. Printing and postage, lines 17 and 19, reflect printing and postage expenditures decreased from last year, primarily due to the elimination of expenses related to the office relocation. However, printing and postage expenses continue to exceed the budgeted amount due to the mailing of CBA's update publication. It's anticipated this will decrease in future years should the board transition to a primarily electronic distribution of update. As referenced in the chart on page 4, enforcement-related expenditures have continued to increase significantly over the last 5 fiscal years. Page 5 provides the CBA's revenue, which reflects approximately $10 million for fiscal year 2017-18. Revenues increased slightly, but were consistent with the previous fiscal year. Page 6 identifies how the CBA's budget is allocated to each division, the primary amount being spent in enforcement. On page 7, we provide information on the fund condition statement, although it hasn't been finalized. Preliminary information received from the DCA reflects the CBA's ended fiscal year 2017-18 with approximately $27 million in the reserve fund. This translates to 22 months in the accountancy fund reserve. The fiscal year 2018-19 budget is currently set at $13,981,000. I just wanted to highlight and commend staff on page 7 of the report, licensee population versus staff level. I think the metrics are very impressive, showing how we're handling 105,146 licensees with staff level reduced over the last number of years. So staff should be commended for that. Thank you, Mr. President.
Thank you. Any questions? All right, that completes yesterday's agenda. Now we'll go on to today's. We'll go with the report of the executive officer, Ms. Bowers.
I do not have a staffing report, and so with your permission, I'll invite Mr. Bone up to give the other item.
Nice to be back, Mr. President. I'd like to provide a highlight and a couple of updates from my written outreach report. First, many thanks to Ms. Salazar for giving the keynote address on Sunday during the Labor Day weekend at the annual convention of the National Council of Philippine American Canadian Accountants. The organizers informed me they were honored to have Ms. Salazar and were inspired by her comments, and they also expressed gratitude to the President for his welcome message that was presented in the event materials. Second, I'm happy to say we have a date set for the So You Want to Be a CPA webinar, which we're holding in conjunction with Cal CPA. That event will be on Monday, October 15th. The main audience for this event are individuals about to complete their bachelor's degree or those who recently graduated. Therefore, we will review all the requirements for licensure, but with a particular emphasis on the CPA examination and experience requirements. This event is a webinar, and CBA staff will be participating remotely. Finally, Mr. President, discussions are underway in partnership with Cal CPA to develop new outreach opportunities to their members who are our licensees. I look forward to providing further comments as we make progress. That concludes my remarks, sir.
Thank you. Any questions? Okay, report on the activities for the Business Modernization Program or project. Deanna.
Thank you. I won't go back over the Business Modernization Project. Ms. Bowers has talked about it yesterday quite a bit. I'm happy to answer any questions that members may have about it. Just to provide an update, one of the first formal processes in this project is to complete our Stage 1 business analysis, which basically lays the foundation of what our needs are and has to get reviewed by Department of Consumer Affairs, Business Consumer Services and Housing Agency, and ultimately by the California Department of Technology, and that kind of gets the process formally going. So in collaboration with DCA, we finished that up in late August, and it's moving forward. I received word just late this or earlier this week that it's pending at Business Consumer Services and Housing Agency, so I think we're making great progress on that. As this project is going to be completed over several years, we are moving forward with an interim plan to accept credit card payments. That's on the agenda as another topic, but we are on schedule to implement that in November 18, and so I'll let our licensing chief talk a little bit more about that when it comes to her report.
Thank you. Any questions? Okay. Now a report from the Enforcement Advisory Committee. Mr. DeLizer, the committee vice chair.
Substituting in for Joe Rosenbaum. This agenda item, the CBA is being asked to adopt or modify the dates and locations for the EAC's meetings for 2019. They're in the materials briefly. They're February 7th and May 2nd in Southern California, July 11th in Northern California, October 3rd and December 5th back in Southern California.
Do I have a motion?
I move to approve.
Any discussion? Any public comments? Please call for a vote.
Jose Campos?
Yes.
George Familet?
Yes.
Mary Gion?
Yes.
Carrie Ann Farrell-Hines?
Yes.
Dan Jacobson?
Yes.
Deirdre Robinson?
Yes.
Katrina Salazar?
Yes.
Michael Savoy?
Yes.
And Mark Silverman?
Yes.
Motion carries. We'll just skip ahead so you don't have to play musical chairs, if you don't mind giving a report on the Peer Review Oversight Committee.
All right. The committee met August 17th here in the CBA offices in Sacramento. We'd like to thank Mr. George Familet for appearing and providing an overview of the CBA's activities from both its May and July 2018 meetings. The agenda was pretty full for that meeting. I'll hit some of the highlights of things that we did. The PROC members reported on the various oversight activities that they had conducted between the previous meeting on May 11th through the August 17th meeting. Additionally, the committee discussed revisions for 2 of its checklists related to the oversight of NASBA's Compliance Assurance Committee meetings and the administrative site visit of the California Society of CPAs. The PROC also discussed a procedural revision to that administrative site visit. We've had to modify how we conduct that site visit here after the implementation of the AICPA's PRIMA tool for conducting peer reviews. We've had to kind of modify how we oversee that. The PROC members also reviewed the 2017 annual report in preparation for going over the format and the items to be included in our 2018 PROC annual report. That report will be further drafted in our December meeting. It'll be finalized in our February of 19 meeting and then presented to the board in your March 2019 meeting. We reviewed and discussed communications between the Board of Accountancy, the Society of CPAs, and the AICPA regarding the progress on developing a framework to monitor the California peer reviewer population. We've no findings at this point to provide any feedback to the board, but continued discussions are ongoing in that arena. The PROC members discussed and made improvements to the oversight procedures for its out-of-state administering entities. We accepted a new monitoring framework requiring oversight of the top 20 administering entities with high volumes of out-of-state firm registrants over a 2-year period. PROC also received an update from CBA staff regarding the CBA Peer Review Program Service survey and its report. Our next meeting will be held December 6th here at the CBA's office. Are there any questions?
Do you also seek approval for meetings in
meeting
2019?
Dates in 2019.
Has everybody looked at those?
I move approval.
Second.
Is this the one that got amended for the one date?
The one date.
As amended?
Second. Any discussion, public comment? Please call for a vote.
Okay, Mark Silverman,
Yes.
Michael Savoy.
Yes.
Katrina Salazar,
Yes.
Deirdre Robinson,
Yes.
Dan Jacobson,
Yes.
Carrie Ann Farrell Hines.
Yes.
Mary Jiang,
Yes.
George Familet,
Yes.
and Jose Campos.
Yes.
Motion carries. Thank you. Next, the report on the Qualifications Committee. Gina, please.
Yes, thank you. This item includes the proposed meeting dates and locations for the Qualifications Committee meeting for 2019. Mr. Evans has already reported on the July QC meeting itself, which was held the day before the July CBA meeting. So it is recommended that the CBA approve the QC meeting dates for 2019.
Move to approve.
Second.
Any discussion? Public comments? Call for a vote.
Jose Campos,
Yes.
George Familet,
Yes.
Mary Jiang,
Yes.
Carrie Ann Farrell Hines.
Yes.
Dan Jacobson,
Yes.
Deirdre Robinson,
Yes.
Katrina Salazar,
Yes.
Michael Savoy.
Yes.
And Mark Silverman.
Yes.
Motion carries. Moving ahead, so you don't have to jump up again,
Thank you.
give you a report of the licensing chief. And I know there's no specific report because Ms. Bowers covered the licensing report in the Sunset Review report, but there is a small little deal on the credit cards.
Yes, a quick update on our very exciting credit card project. As discussed at the previous CBA meetings, the DCA is overseeing an implementation of a credit card portal, which will allow licensees to pay their renewal fees online through a contracted vendor named Elevon. Members requested that staff research the impact this will have on our licensees and on CBA's internal processes. Once launched, a licensee will click to pay their renewal from the CBA website and will be prompted to answer a set of questions and enter their identifying information like name and license number. Once that information has been validated, the licensee will be directed to the Elevon credit card payment portal. This screen will appear to the licensee as an extension of the CBA website. However, all credit card information will be processed by Elevon. No credit card information will be processed, stored, or collected by the CBA or DCA servers. The licensee will then be directed to submit their signed renewal form to the CBA to ensure that all renewal requirements are met. Nightly, a transmission report will run, and the licensee's information will be updated into the CBA's database, which we know as CAS, the old legacy database. And will also be updated on CBA's license lookup, most likely the next business day, within 24 to 48 hours. So this new process is a much easier and faster way for our licensees to renew their CPA license. As soon as the database is updated by that nightly transmission, the process begins to issue the licensee's new Pocket ID card. Currently, payments submitted via mail must be cashiered and processed prior to the release of the licensee's Pocket ID. With this new process, it is expected that this will alleviate the 2 weeks it takes to receive the mail and manually cashier the payment. So internally, for CBA staff, this process is still being finalized. However, it is expected there will not be an additional workload impact on CBA, as the receipt of the renewal is still a requirement. Alternatively, however, it is expected to reduce the licensee phone calls and stakeholder contacts we get in regards to the receipt of payment and the status of a license renewal. So that will alleviate some time for us. As a way to ensure our licensees are informed of this new payment method, the CBA staff have developed a robust outreach plan, which is outlined on page 3 of this agenda item and includes, but is not limited to, a video announcement, mailers, update articles, collaborating with Cal CPA, and much more. So that concludes my report. I will now turn it back over to the President.
Thank you. Any questions? Thank you very much. Next item is the report of the Enforcement Chief. Dominic.
Thank you and good afternoon. So I'll just touch on a couple of items to keep us moving. So the report you have for the year is your full fiscal year data for 17-18. We ended the year with just over 2,400 complaints, which is similar to the number of complaints we had in 16-17. Directing your attention to page 4. On the current inventory of investigations pending, we are continuing to see a decrease in the number of cases over 24 months, which is obviously a focal point. When we closed last fiscal year was at 114, we're down to 47. And as the report indicates, another 11 of those cases are either being referred to the AG's office or will be closed. So hopefully we're going to be able to continue to drive that number down. Moving to page 6. The AG referrals, we referred 81 cases, again, similar to last year's pace. And the inventory at the AG's office, which is reflected on your next page, is at 69, as I mentioned yesterday in the Sunset Review report. This number continues to continue to go down. We work aggressively with the AG's office to get matters resolved as quickly as possible. Lastly, the last highlight I'll note is that final orders for last year, the board took action on 90 matters, which is just slightly less than the high of all time last year, but still a significantly larger number than previous years. And with that, I'm happy to turn it back over and I'll answer any questions members may have.
Any questions? Thank you very much for your report. Says lunch, we'll skip that. Jose, your report on the mobility task force.
Item XB2 was discussion and possible action regarding the ongoing determination of other states' substantial equivalency enforcement best practices and disciplinary disclosures. The MSG discussed possible actions regarding the ongoing determination of states' substantial equivalency to enforcement best practices, disciplinary disclosures. Staff presented a framework for MSG consideration that was divided into 4 categories and the use of a survey. Staff noted that it would take the lead in collecting and reviewing the necessary information, and NASBA would assist and perform follow-up steps as necessary. And really the aim of the process being a risk assessment driven process for monitoring purposes to fulfill our consumer protection objectives. Staff identified 3 states Texas, New York, and Oregon as the first states that would be subject to the review framework. Staff also noted that this was a pilot process and adjustments would be evaluated based on the information gathered. Some members raised concerns regarding certain data points, especially those that made up the survey-related questions. This included requests from states regarding enforcement budgeting and staffing and how states impose discipline against licensees that is appropriate in light of the nature of the alleged misconduct. After discussions, the MSG recommends that staff provide additional information regarding Category 4 on peer review oversight activities and what information or data would be collected and relevant to the evaluation. Further, looking at the table on page 3 of the materials, the MSG also recommended that staff conduct the proposed review of the 3 states using the categories and data points identified by staff, with the exception of deferring Category 1 points A and B, Category 3 point B, and use of the survey in Attachment 2. Staff will report back to the MSG on whether the data alone was sufficient enough to make a determination regarding substantial equivalency. Long recommendation.
Yes.
That's a recommendation.
So that comes to us as a duly formed motion and a second. Therefore, is there any discussion at the board level regarding any of that? Any public comments? Call for a vote, please.
Mark Silverman,
Yes.
Michael Savoy.
Yes.
Katrina Salazar.
Yes.
Deirdre Robinson.
Yes.
Dan Jacobson.
Yes.
Carrie Ann Farrell Hines.
Yes.
Mary Jiang.
Yes.
George Familette.
Yes.
And Jose Campos.
Yes.
Motion carries.
Final items. Item XB3 was discussion of the mobility activity report. Staff presented the most updated draft of that report, which continues to evolve. Informational item and no action needed. And then there was a written report under item XB4 on stakeholder objectives.
Thank you very much for your report. Now, the Committee on Professional Conduct, Deirdre Robinson.
Today we met on XA2, the discussion and possible action to make non-substantive changes to Form PP13 incorporated by reference in Title 16 California Code of Regulations, Section 20, to update the reference from Board of Equalization to California Department of Tax and Fee Administration. Staff reported that the purpose of this agenda item is to provide the CBA the opportunity to consider taking action to amend CBA Regulation Section 20 and out-of-state firm registration form PP13 to update the reference from Board of Equalization, or BOE, to California Department of Tax and Fee Administration, or CDTFA. The proposed changes are non-substantive and do not alter any requirement, right, or responsibility of CBA or its applicants or licensees. Rather, the proposed changes would simply update the name of the state agencies from BOE to CDTFA. As these changes are technical in nature, staff will submit these amendments to the Office of Administrative Law as Section 100 changes, which take effect 30 days following submission to OAL. The CPC recommends the CBA, number 1, approve the regulatory text and form incorporated by reference in CBA Regulation Section 20, and 2, authorize the executive officer to initiate the formal rulemaking process for a Section 100 change, including submitting the text and form changes to AOL. XA3, discussion and possible action on
We have to have a vote.
Oh, sorry.
Yeah, if you put a duly formed motion and a second, is there any discussion? Any public comments? Call for a vote, please.
Jose Campos.
Yes.
George Familette.
Yes.
Mary Jiang.
Yes.
Carrie Ann Farrell Hines.
Yes.
Dan Jacobson.
Yes.
Deirdre Robinson.
Yes.
Katrina Salazar.
Yes.
Michael Savoy.
Yes.
And Mark Silverman.
Yes.
Okay. 10A3, discussion and possible action on the international delivery of the Uniform Certified Public Accountant examination. Staff stated that the purpose of this item was to provide the CBA the opportunity to discuss whether it would like to participate in the international delivery of the Uniform Certified Public Accountant examination, or I-exam. I-exam has been in existence since 2001 and is offered in various locations, including Japan, Brazil, and the United Arab Emirates. Beginning October 2018, the I-exam will be offered in England, Germany, Ireland, and Scotland. Like the CPA exam administered nationally, the I-exam is also administered by Prometric. Staff explained the I-exam application process and stated that to qualify to take the I-exam, California candidates must first apply through the CBA. After the candidate is approved to take the I-exam, they must agree to the NASPA consent form. The NASPA consent form indicates, among other items, that an applicant must become licensed within 3 years of passing the I-exam on their score, or their scores will be withdrawn. California candidates who pass the I-exam must meet all education and experience requirements in accordance with CBA regulations. Additionally, staff indicated that they will work with legal counsel to identify any needed statutory or regulatory changes and will present at a future CBA meeting. So the CPC recommends the CBA approve participation in the international delivery of the CPA exam and direct staff to prepare a communication to NASPA conveying the CBA's action.
Duly formed motion and second. Any discussion? Public comment? Call for a vote, please.
Mark Silverman,
Yes.
Michael Savoy.
Yes.
Katrina Salazar,
Yes.
Deirdre Robinson,
Yes.
Dan Jacobson,
Yes.
Carrie Ann Farrell Hines.
Yes.
Mary Jiang,
Yes.
George Pamela,
Yes.
and Jose Campos.
Yes.
Motion carries. Thank you very much. Next item on the agenda is item 11, minutes. There is a minor edit to the item 11A, which is the minutes of the July 26th, 18 CBA minutes. The first edit is to 12A1A, which is on page 20,093, to incorporate the words "and testing" in reference to where it says "to globalization with the MRA locations." The second edit is to item 12B1 on page 20,094, within the third paragraph, to change "this pathway" to "IT concerns." Can I get a motion to approve with the changes?
I would make a motion, but I would add a third change to that on page 20,072. There's a paragraph in the middle that begins, that's dealing with SB 795, right before the motion. And there's a "have the" phrase that's in there twice.
Very nice.
I'll second that motion.
Okay, so with the two and with the three changes, second, any discussion, any public comment? Call for a vote.
Jose Campos.
Yes.
George Pamela.
Yes.
Mary Jiang,
Yes.
Carrie Ann Farrell Hines.
Yes.
Dan Jacobson,
Yes.
Deirdre Robinson,
Yes.
Katrina Salazar,
Yes.
Michael Savoy,
Yes.
and Mark Silverman.
Yes.
Motion carries. I'd like to incorporate items B, C, D, and E for the approval of all of those.
I move approval.
Second.
Any discussion, public comment? Call for a vote, please.
Mark Silverman,
Yes.
Michael Savoy,
Yes.
Katrina Salazar,
Yes.
Deirdre Robinson,
Yes.
Dan Jacobson,
Yes.
Carrie Ann Farrell Hines.
Yes.
Mary Jiang,
Yes.
George Pamela,
Yes.
and Jose Campos.
Yes.
Motion carries. Thank you. Item 12, other business. The American Institute of CPAs report on the meeting attended by the State Board. Katrina?
Oh, certainly. Would you indulge me just covering my several items here?
Okay, as long as you talk fast.
Thanks. So, so on the state board committee, the next scheduled meeting is actually in early October. It will be in Orlando, so I will be participating, hopefully remotely via technology. So I will report more after that. In terms of the other items that reflect my name, there is an upcoming NASBA board meeting, which will be in Arizona. That will happen in October, so I don't have any updates to the Bylaws Committee, which is 3A, or the Enforcement Resources Committee, which is 3B. I would like to report that on the Relations with Member Boards Committee, that is the committee where, as Region Director, I coordinate and host a call to communicate with all of our region participants, and that is all the way from the Commonwealth of the Northern Marianas Islands to Alaska to Arizona. So it's that sort of Pacific region to talk about issues and concerns. And that happened on September 5th. And where I am able, I will also listen in on the other regional calls that happen throughout the country. There are about 5 or 6 of them. So I do try to participate and listen for concerns and areas of interest. The big thing is clearly legislation is waiting to be finalized. And as I'd mentioned in my presentation yesterday, there is some concern about deregulation and the potential impact on mobility as various legislatures wrap up and new recommendations are being put together for the next round of legislative action. So with that, I have D, Strategic Planning Task Force. NASBA did hold that planning meeting. It was a 2-day-long event that I participated in by phone, and a draft has been created, and it will be subject to board approval in October. So with that, I hope people will consider attending the NASBA annual event, which is coming up in October, if they have already expressed interest to Patty in attending. So with that, thank you.
Thank you so much for that. I think we have another item regarding discussion and approval of staff responses to the national focus questions. Rebecca?
Okay, the purpose of this agenda item is to provide the CBA with staff proposed responses to the NASBA focus questions. The responses assist the NASBA regional directors with staying apprised of each state's policies, procedures, and recent activities. The CBA may make a motion to delegate to staff the completion of question number 4 and approve the attached focus questions or direct staff to make any changes prior to submitting the responses to NASBA. And at this time, I would like to turn it back over to President Savoy and would be happy to answer any questions.
Any questions? I think we need a motion to either approve or direct staff to make changes to any proposed responses.
So moved.
Second.
Any further discussion, public comment?
I assume there was a motion to just proceed with them as presented?
Yes. Call for a vote, please.
Jose Campos,
Yes.
George Familet,
Yes.
Mary Jiang,
Yes.
Carrie Ann Farrell Hines.
Yes.
Dan Jacobson,
Yes.
Deirdre Robinson,
Yes.
Katrina Salazar,
Yes.
Michael Savoy,
Yes.
and Mark Silverman.
Yes.
All right, Katrina, you gave all your reports on NASBA, correct, or?
All done?
Okay. Wow. At this time, I call for any public comments. Any items for future agendas? With that being said,
I'm sorry.
yes, sir.
This goes back to something that we had said before. I just want, the whole issue of whether a crime is substantially related to the profession of accountancy. I had said before that I would next year ask that be agendized because the language may change, and it looks like it's not changing, so I will be asking for that next year.
Thank you. Any other items? With that, we go into closed session to deliberate on pink sheets. Okay, we are now back out of closed session. Thank you all for being here. This meeting is now adjourned.